Hi, I'm Emma and I'm head of the Court Protection team here at David Gray Solicitors. We have a specialist dedicated team here who can cover a multitude of various issues within the Court Protection. One of the areas that we have particular specialism in is what we call Section 21A Mental Capacity Act applications. So Section 21A applies to what we call a standard authorisation or a DoLS. When somebody is deprived of their liberty in a care home or deprived of their liberty in a hospital, they should be subject to something known as a standard authorisation. That paperwork often is referred to as a DoLS, which stands for Deprivation of Liberty Safeguards. If you are the person that is deprived of your liberty, then you will have somebody allocated to you called a relevant person representative, or for short, an RPR. In some cases, this might be a family member, but a lot of the time it will be a paid advocate. Their job is to ensure that if you want to challenge the DoLS, that they assist you to do so. My job as a solicitor in the Court Protection Department is to take instructions from the RPR. And if the RPR tells me that you're not happy with being detained in the hospital or the care home, then I can support you to bring that matter before a very specialist court called the Court of Protection. Unfortunately, the proceedings are not quick and it can take a few months for matters to be resolved, but the court will deal with your matter as soon as it can do. The judge in the Court of Protection will have to ask themselves various questions. First of all, they need to decide whether you have capacity to make various decisions for yourself. For example, can you give me instructions directly? And if you can't, then you'll be allocated a litigation friend and they will tell me what to do. They will give me instructions. The judge will also look at whether you have capacity to decide on your accommodation and also your care and support needs. If the judge feels that you have capacity to make those decisions for yourself, then the judge will let you do so and won't interfere. If, however, the judge has evidence that you don't have capacity to make those decisions, then the judge has to go on and decide what they think is in your best interests. There will be what we call evidence put before the court and for the judge to consider to help them make that decision. That usually comprises of a statement written by a social worker. And in that statement, the social worker will have to look at what the options are available for your accommodation and for your care and support. And they'll have to conduct what we call a best interests analysis and decide what they think is in your best interests. My job as your solicitor is to come and see you, ideally along with your relevant person representative, and to go through that statement with you to the best of your ability. My job is to ascertain what your wishes and feelings are, and I will put them down in a statement and make sure that the judge and anybody else involved in the case knows exactly what you would like to happen. The judge has various powers at the end of the case. They can leave the standard authorisation in place, they can vary the terms of it or the length of it, or they can leave things as they are. But even if the judge chooses to leave things as they are, there can still be some subtle improvements to your life if you do have to remain in the hospital or the care home. This could involve things such as you getting out and about more or taking part in various activities that you might enjoy. If you are a family member and you are the relevant person representative, then you may or may not agree with a challenge being brought to the Court of Protection, but may feel that you have to do so as part of your role as the relevant person representative. We understand that this can be very difficult for you, but we will support you and the relevant person if that's what needs to happen. In terms of funding, if you are the relevant person, then you're entitled to what we call non-means tested legal aid. That means that whilst you're subject to the standard authorisation or the DoLS, then I can conduct your case at no cost to you. If you're the relevant person representative, then you're also entitled to non-means tested legal aid. And that's whether you want to be a party to the proceedings yourself or not. So you may choose to bring the proceedings on behalf of the relevant person, but you may not agree that the standard authorisation should be varied or terminated, and you may want to have a voice in the proceedings. We can ask the court that you become a party to the proceedings in your own right, and we can represent you, subject to non-means tested legal aid also. If you're a family member and you would like to be joined as a party to proceedings, we can talk through that with you, and we can also talk through the options for funding. You might also be entitled to legal aid, and we can look at that with you. If you have any questions at all, please contact our dedicated team here at David Gray Solicitors, and we'll be happy to help you.